A very good morning to all my dear students. On behalf of ICAI, I welcome you for today's revisionary class. So this is your last revisionary class, I suppose, and I think you have one more after this. Good morning, Tanu. Good morning, Asta, Almas, Pooja, all of you. Welcome to the class. So today we'll be completing two topics, children. One is LLP and another is foreign companies. So without wasting further time, let's start with limited liability partnership. So it's your revisionary class. You have already done LLP. You have already made the notes. And in today's class, we'll understand and have a quick recap. We'll be doing examination questions so that you are very well aware of how to attempt these kind of questions in the exam. So children, what is the meaning of LLP? Before we proceed further in the class, let me remind you that LLP is something which is a related topic which when we were CA Foundation student, we have studied a bit about it. And partnership was full-fledged over there. So something that comes between the partnership and the companies is LLP. Having the flexibility of partnership agreement and at the same time getting the corporate structure of a company. Is that clear? You see the chat box. Okay. So LLP is a structure of the company and flexibility of partnership. Why the need for LLP arose was because it became so difficult for people, the burden of unlimited liability of partnership was there. So government thought of encouraging entrepreneurship, helping the professionals and enterprises to come up with their technical disciplines and also forming a commercial vehicles for the requirements. So LLP is the most suitable kind of organization in nowadays. Yes, the annotations are disabled, sir. Yeah, it is disabled, sir. Manish, sir, I have disabled it. All right, all right. So what are the advantages of LLP? Now, examiner can give you a straightforward question also from this chapter, like what is the need or what are the advantages. If you ask me, ma'am, what is important, what is unimportant, so I keep telling you every time, everything that is given in the study material is very, very important for us. So we cannot leave a single line or a single page. All right. So LLP gives us the benefits of the company's limited liability and flexibility of agreement. So it's a separate legal entity, the biggest advantage. So LLP is different, its partners are different. If there is only one partner in LLP, then the sole partner without dissolution, he has to find a new one. Otherwise, it will be considered as a sole proprietor. So it's a new legal form of entity, flexibility, the salient features we'll be quickly doing because children, we have to complete two topics. So we'll be just quickly rushing through the revision because I want to do some important questions also with. So it's a body corporate perpetual succession. You all remember the similar kind of features when we started with Companies Act. It has similar features, few of the Companies Act, and mutual agency is from the partnership. But here the partners are not agent of each other. They are agent of the LLP. Then we have agreement. So you'll see again, this was not there in companies, but this is there in the LLP. Artificial legal person, it's a judicial person who is working separately from its partners. Common seal is there. So common signatures that we used, LLP also has a common seal. Can anyone tell me how many designated partners, in front of how many designated partners the common seal needs to be signed? I'm going to check your answers. Yes. How many DP should be there? How many designated partners have to be there? At least two. Very good. Excellent, Almas, Pooja, Tanu, everyone those who have answered. Wonderful. So limited liability is the biggest advantage of the LLP. How many minimum partners we have? Minimum two partners, two DP. So if you have only two partners, can we appoint them only as DP? Yes, that is also fine, but two DP has to be there. Out of five partners, two are DP then. Is there any maximum number of limit of partners in case of LLP? Tell me yes or no. Very good. No limit. Excellent, Pooja. Kirti. Yes, correct. No limit. Now, what is foreign LLP? Like we have a foreign company, similarly, foreign LLP, which is formed, incorporated, and registered outside India and having a place of business within India is considered as a foreign LLP. Now, this is a very, very important definition, which again correlates with your LLP also and foreign companies also. What is a body corporate? Now, children, body corporate is defined under Companies Act also. Body corporate is specifically defined under LLP also. So if I ask you if any LLP is registered outside India, can it be considered as a body corporate? Yes or no? If any body corporate, if any LLP is registered outside India, can we call it a body corporate? Yes or no? Definitely, it will be considered as a body corporate. Very nice. And if I ask you that there is an LLP which is registered in India, then anyways, it is a body corporate. So body corporate is a elaborative definition which tries to cover the LLP incorporated within India and outside India. And what is not included in body corporate? Give me the answer. What all is not included in body corporate? Corporation sole, excellent. What else? Cooperative societies registered. Excellent. All of you have given the correct answer. Very nice, Asta Sethi. Both the options are correct. So after that, financial year's definition, let's have a quick recap. So what is the date to be considered and remembered in case of LLP? Is it 30th September or 1st of January? If the LLP is incorporated after 30th September or 1st of January in order to have the next financial year. Excellent. Almas, Tanu, Pooja, everybody is answering so smartly. So 30th September is the date. 1st January was the case of companies. Then we have LLP agreement. It is a written agreement. So these are the definitions. 2 marks definitions can also be asked in the exam. So LLP agreement tells the rights and duties of the partners. Now, another important definition out of which most of the time we get important questions, that is small LLP. Now, what we have to remember over here is the contribution does not exceed 25 lakh rupees and the turnover as per the statement of account and solvency. Children, I told you when we were doing LLP, we have statement of account and like we do P&L and balance sheet and other financials. Here we use the statement of account and solvency. Means ये अभी organization solvent है, इसका दिवालिया नहीं निकला है, it's a solvent kind of situation. Okay, that means they're doing business. So we prepare a statement of accounts and solvency and turnover should not be exceeding 40 lakhs. So what are the two conditions? And is over here. So 25 lakhs and 40 lakhs you have to remember, or other requirements that may be prescribed at the terms and conditions. So my question to the class is, if the LLP is having 35 lakhs of the contribution and 39 lakhs of the turnover, is it a small LLP? Yes or no? It is having 35 lakhs of the contribution and 39 lakhs of the turnover. Will it be considered as a small LLP or not? Let me check your answers. Manivanan. Yes, for the next financial year, absolutely. For the previous financial year, we have to see. So no is the correct answer, Manivanan, because both the conditions child has to be satisfied. Okay. So it says and. All right. And who are the partners? Who cannot be a partner in LLP? Come on, tell me. Who is going to raise their hand and answer this one? Let's make the class interactive, children. This is your revision going on, and you all know these points. I'm going to jump to the case studies as soon as we have completed the revision. Yes, who is going to tell me who cannot be a partner? Unsound mind, undischarged, insolvent, and even if you have been application of insolvency is pending, then also you cannot be a partner. Minimum number of partners. What is the time period to be remembered over here? If you continue the business being a single partner for more than 6 months, then you will become personally liable. All right. Who is a designated partner? So the important definition of designated partner, one of them have to be a resident in India, one of them. So if another partner is non-resident, one is resident. Is it applicable? Is it fine? Yes. One of them have to be a resident in India. And can we have body corporates as a partner in LLP? So there is a company, ABC Limited, who is partner in LLP. And there is PQR LLP, who is a partner in LLP. Ma'am, you said minimum 2, we have minimum 2. Who will be appointed as the designated partner? We cannot appoint. Company is somebody who cannot be seen or cannot be, is not a person, original person, but something has come into existence. We always do that, artificial judicial person. So here, who will be considered as the nominees of these? Yes, nominees of these people will be appointed as the designated partner. So then we have incorporation. Let us quickly do some case studies. So Mrs. Strong Steels Limited Liability Partnership was incorporated on April 2010 with 10 partners. The LLP had very good business and made considerable profits during the past years. Recently, due to obsolete practices, Strong Steels Limited LLP started making loss. Also, it did not file its annual returns from 2020 to 21. 3 partners decided that LLP should be wound up by the tribunal and remaining partners objected to it. Now, he has given you the section also. So, I keep telling you sections are not compulsory for writing in the exam and not important for LLP. At least we can leave the sections. But at least when you're revising, when you're learning, you should be aware about the section. So referring to section 64, please tell whether the tribunal can pass the order and what are the provisions and penalties. Now, since it's a revisionary and I really want you to do proper case studies also. So let us quickly have a run through section 64 from the module. And then I would be expecting you all to answer me this question. So let's open chapter number 12. So it says winding up and dissolution. Winding up of LLP can be done voluntarily or by the tribunal. तो अपने आप से भी आप डिसाइड कर सकते हो कि मुझे LLP को wind up करना है या फिर tribunal order pass. What are the circumstances in which tribunal will pass the order is straight away given under section 64. कौन से circumstances होंगे जल्दी से रिवाइज कर लेते हैं. If LLP decides that it should be wound up by tribunal more than 6 months, number of partners reduced below. अभी मैंने आपको एक प्रोविजन कराई ना कि अगर more than 6 months हो जाते हैं and partners below 2 हो जाते हैं. If you have acted against the sovereignty and integrity of the state, आपने public government के against कुछ अगर आपने कर दिया. If LLP has made a default in filing with the registrar a statement of account and solvency and annual return. So we have read this in the question, annual return for any 5 consecutive financial years अगर आप default करते हो तभी. So 5 consecutive years underlined, this is important from here. If the tribunal thinks that it is just an equitable, tribunal को लग रहा है कि कुछ गड़बड़ कर रही है तो वो wind up कर सकते. Now 5 cases are given directly under section 64. Here is how we have to attempt the answer. So section 63 first tells you that you can be wound up either voluntarily or by the tribunal. If you have made, so here He's specifically talking about the default in filing the statement. You can give the 5 points. Yes, all those who are asking, ma'am, do we need to? Yes, yes, you can. Even if you don't mention about section 63, it's okay. Section 63 नहीं, section 64 की points उसने specifically पूछे हैं. ये तो सिर्फ हमने एक line बता दी that yes, binding up can be done voluntarily or by the tribunal, just introducing the section to it. So LLP tribunal कब wind up कर सकते हैं? One of the points says that if you have defaulted in filing the statement of account and solvency and annual return for 5 consecutive years, he did not file from 2021. In the financial year 24-25, the default has not continued for 5 consecutive years. Because this is the underlining line. उसने एक ही point के ऊपर आपसे क्वेश्चन पूछा कि 5 consecutive years हुए कि नहीं. 2021 से नहीं फाइल करा, 21, 22, 23, 24, 25 में 4th, 5th year में आकर आप फाइल कर रहे हो. So default has not continued for 5 consecutive years. He is telling you, na, he did not file from 2021. Recently, he has filed. So here, keeping in view of the facts and the questions and provisions, the remaining partner's objection is correct. He shall file the annual return with the registrar as per section 35 within 60 days of closure. तो फिर थोड़ा बहुत annual return के बारे में भी आप देख सकते हो कि what is the time period? What is the time period for filing the annual return? Tell me. This is, you have to tell me this. Every LLP shall file the annual return duly authenticated with the registrar within dash days. Let me see the answers. Yes, Manivanan, what is the correct answer? Tanu, good answer for the previous one. Astha Sethi, you will not say that the company appoint body corporates as DP. We use the word nominees of those body corporates. Okay, beta? Within 30 days, Tanu, that's wrong. Pooja, I'm checking your answer. Good. 60 days is the correct answer. Astha, you have still not sent your answer. Kirti. Almas, excellent. 60 days. Very good. Yes, very good, Astha. 60 days after the closure of financial. Okay. And for default of filing the annual return, you can, if you remember the fine and penalties, because he's asking you now, also shade the provisions and penalties. So beta LLP एक छोटा chapter है, foreign company छोटा chapter है, तो इसकी penalties learn कर लेनी है हम. I told you, and when we do a huge companies act, it becomes very, very difficult to learn all the forms and all the penalties, and just for 2 marks or 3 marks, we keep on revising and learning it, and at times we tend to forget it. But again, by repeating again and again, it gets fed over here in subconscious mind. So none of you have written this penalty of 100 to 110,000 rupees. So LLP की penalties, foreign companies की penalties, registration of charges and deposits, छोटे chapters है, उनकी penalties learn कर लो. Audit and auditors की penalties बहुत important है, वो learn. Big chapters like Incorporation, MGT, just go through the penalties. As I have already told you, write it down on the first page of the chapter and stick it down and just give a flip through. Don't keep wasting your time just running after the penalties, but these small chapters, learn it. Okay? A, B, C, D are the partners of Alpha LLP and have the equal share in the profits. A has made an arrangement to transfer 70% of his share in the profits of Alpha LLP to his daughter X. X wanted to access the information about the trading transaction of Alpha LLP, claiming that she is entitled to the information. She is receiving a percentage of profits. Partners refused to grant her this access. Now D has transferred some share of profits. Sorry, A has transferred to his daughter X. A is transferor, X is transferee. Transferee wants to seek the information. Can X, the transferee, has any remedy against the denial according to the provisions of Partnership Act, LLP Act? Are the partners correct? दो question पूछे हैं उसने आपसे. I would want you to raise your hands and answer me this one. Yes, who is going to raise your hands? Yes, Tanu, now you have corrected your answer. 60 days is the correct answer for this. Read the question very carefully, children, and answer me this. Yes, very good. If you remember section, you can quote the section. Otherwise, I told you LLP. You can just simply tell me the answers without the sections. Give me the answer for this one. Can X intervene in the information? When it says what remedy he has means what kind of solution as a legal advisor, what solution you're going to provide them. This is what he's asking. Very good, Astha. Almaz, good answer given. All right. Now, how we have to attempt in the exam? If we don't remember section 42, what will we write? As per the, and make sure to have 3 separate paragraphs for the case study, children. Very, very important. As per the provisions of LLP Partnership Act 2008, ये नाम correct होना चाहिए. 2010 मत लिखना ना, ये एक्ट के नाम correct लिखने. Companies Act 2013, LLP Act 2008. What does it say? Is the rights of the partner to transfer the share of profits and losses and to receive the distribution according to the LLP partnership arrangement agreement. They can transfer either wholly or in part. पहला point ये हो गया. Transfer of the right does not entitle, very, very important point. ये आपको provision में लिखना पड़ेगा. That it does not entitle the transferee to participate in the management and conduct of the activities of LLP or to access the info. Then separate paragraph, you will say in the given question, the partners, now he has just given you conclusion. So children, when we are attempting CA intermediate paper, sometimes the paper is very huge. You have to consider the time limit as well as the marks assigned to a particular question. अब अगर ये 2 नंबर का क्वेश्चन होगा, सिर्फ yes and no पूछता है, तो अगर मैं ये प्रोविजन लिखकर कंक्लूजन लिख दूंगी, then also it's fine. If it is 3 to 4 marks question, then I need to have a separate paragraph elaborating the facts of the case also. That in this question, the amount transfer of interest by A to X has been done, and X is trying to interfere in the management. छोटा लिखना facts of the case, बहुत बड़ी बड़ी कहानियां नहीं बनानी है माँ. Conclusion, analysis and conclusion based on the above provisions and analysis. Alpha LLP are correct in denying the excess of information, and X does not have any remedy against the denial. Now, if you write only this part and you don't give your elaborative explanation of the provisions and do the analysis, you will hardly get 1 or half of it. Because your answer is correct, your conclusion is correct. That's why we are having revisionary for you children, because now is the time that you start learn how to attempt the exam, how you have to write the answers. That is the most important part. So the beauty of law is by reading it again and again, by understanding the explanations with the teachers you are advising, you tend to learn the things. But the only problem occurs is how to attempt the questions. Again, another important thing, sometimes we come home and we think, I have written 3 paragraphs, I will get marks. It's not just about writing, you have to write correct information. My dear students, sometimes your provisions are not matching with the conclusion. So, कोई बच्चा बहुत सारा लिख कर आ जाएगा इस पे provisions पे LLP बनाते हैं जी, flexibility है, ये है, वो है, उसके बारे में बताया ही नहीं. जो important line क्या थी इसमें? Important line थी that this will not entitle the transferee to participate in the management and conduct or access the information. If you have written this point, you're referring to the provisions, you're writing the facts of the case, you're giving the correct conclusion, then you get this. All right. Yes, Astha, we can appoint nominee as the TP when you have individuals as the partner. So, unke individuals you appoint होंगे ना? That's correct. Yes, Pooja, this was correct answer. So you have also given the conclusion. That's correct. Now we have done 2-3 case studies. Let's go back to the revision. But say incorporation of LLP, I hope no doubt in this. So what you have to remember is 2 or more persons carrying on the lawful business, they can have to sign the document. जैसे वहाँ पे memorandum of association होता है, यहाँ पे incorporation document use होगा. Now, this is the picture that I've taken from Sarang. Another important thing I wanted to tell you for the revision, Institute has beautifully made colorful saransh for you, which is a ready reckoner just for having a summarized revision. So कोई points आपको tough लग रहे हैं, आप summary देखना चाहते हो, for few of the things you can prefer. But if you ask us, ma'am, can we just simply do the saransh and go? Then the answer is no. Study material always remains the Bible for you. These are just the short, summarized, colorful points which uplifts your mood, and we start finding the content and text little more bright and happier while studying. Okay, children, so this statement has to be filed. Then we have this incorporation document, which contains all the name and address and all the details about the partners. If knowingly you are making any false statement in the incorporation document, then what is the penalty? Now, this is very, very important penalty. LLP की penalty is बहुत important. आप झूठ बोल रहे हो incorporation document में and आप submit कर अपनी LLP खड़ी करने जा रहे हो, 2 साल की जेल हो, and fine can extend from 10,000 to 5 lakh rupees. All right. And after the requirements have been submitted, he will register the incorporation document and gives you the certificate of incorporation. Can anyone tell me within how many days he will register and give you the certificate of registration for LLP? It's another question for you. Within how many days he will register and give you a certificate of incorporation? Yes, Almas, 14 days. Very. So again, number of days is very, very important. Keep highlighting it, keep marking it. Then RO of LLP, effect of registration is very, very simple. Name के ऊपर बहुत बार question आता है. So if I am getting a question related to the change in name, I expect you to write section 15. First of all, no LLP will be registered with undesirable or identical name. Once the name has been reserved, the name of the proposed LLP, or whenever he wants to change it, he will have to apply to the registrar. Within how many days? I will be asking a question, you have to answer. Within how many days the name can be reserved? Within how many days the name can be reserved by the registrar for a period of how many days? 3 months. Very nice. Very nice. Everyone has given the correct answer. And if the name is identical or resembles with any registered trademark or any other LLP, then within how many days the registered trademark can file an action against that LLP? Within how much time period? Within 3 years of time period, then only he can file it. And if he has filed an action, then central government will direct them to change the name within a period of 3 months. And the name, if within a period of 15 days, they have not changed the names, then central government will allot them the new name and issue the certificate of incorporation. Is that clear to everyone? Ishan, very good. You have joined the class late, but your answers are correct. Very good, Manivanan, Barsha Chaudhary, very good, excellent. Tanu, Almas, Asta, Kirti, everybody has given the correct answers. So can we say every partner is an agent of each other in the LLP? Yes or no? No. So they are only the agent of the LLP and not the agent of each other. What are their liabilities? The partner has no authority to act according to a particular act, and he has no authority. So LLP is not bound by how you're acting. LLP is liable. If a partner is liable to any person because of the wrongful act, then whole of the LLP will be held up. Partner is never personally held liable for directly or indirectly for any of the provisions referred to 27(3) solely by the reason being a partner. Just because I'm a partner in LLP, I do not become personally liable. However, the provisions of section 27, subsection 3, which is given over here, and 28, subsection 1, will not affect the personal liability for any wrongful act. Simple जो हम इंडियन पार्टनरशिप में पढ़ते थे, पार्टनर्स के लिए फर्म लायबल रहती है. अगर आप wrongful act करते हो तो हम उस पार्टनर से रिकवर कर लेते थे. Similarly, although your liability is limited, but if you do any wrongful act, then you become personally liable for your wrongful action. Logically also it sounds correct, right? Then partner by holding out, जैसे partner by holding out partnership में था, यहाँ पे भी LLP में partner by holding out if by words without spoken, or you're representing yourself, or by spoken words without being a partner, you have told the other person that you're a partner in the firm, and another person has relied on that and given the credit to the firm, then the person, then that partner will be liable to the extent of the credit received by the firm. And where other partners are continuing the partner after the partner's death, the business is continued in the LLP, then also the continued use of the name or deceased partner's property will make the legal representative liable for the acts. Annual return 60 days we have done, and this was the fine up till 1,50,000. Circumstances of winding up also we have discussed. So now we will do some more case studies. Yes, NS and Associates LLP was formed in the year 2020. And it was in the business engaged of manufacturing of plastic parts for automobiles. It constituted of Mr. Naveen and Suresh as designated partners who were responsible for obtaining contracts from the various automobile manufacturers for the supply of spare parts. In the year 2021, investigation was ordered by the tribunal against the LLP in connection with the financial fraud of 50,25,000. J, one of the accounts manager and employee, was accused of the complainant as one of the penetrators to the fraud. So this is the history he has given you, that this is the LLP which was formed in 2020. They are into this business. There are two DPs, Mr. Naveen and Suresh, and they were responsible for obtaining all the contracts. But investigation जब ट्राइब्यूनल ने करा तो उन्होंने देखा 50,25,000 का फ्रॉड था, एंड जे एक अकाउंट्स मैनेजर एंड एम्प्लॉई जो है एलएलपी का उसे एक्यूज करा. ट्राइब्यूनल ने पेनल्टी लेवाई करी 1,25,000 की, which was to be paid by Mr. J on his conviction. मिस्टर जे के ऊपर आपने पेनल्टी लगाती है जबकि एलएलपी ने फ्रॉड करा है, एंड जे अप्रोच्ड द ट्राइब्यूनल एंड प्रोवाइडेड all the vital information about the other black sheep involved in the fraud, thus abiding in the investigation process. Tribunal is trying to give in some relief in the penal action where the LLP is planning to suspend Mr. J from his services. Decide whether tribunal can waive or reduce the penalty. Can the LLP suspend Mr. J for service? कोई मुझे इसका टॉपिक का नाम बता देगा ना, I will be very happy. Can the LLP suspend Mr. J from service or commission or revealing the name accused by the firm? You can tell me the topic with very good and mass. I'm super, super proud of you. Excellent. Anybody else can name the topic? Very good, Asta. Whistle blowing. अनाउंस कर दिया, शोर मचा दिया कि एलएलपी में गड़बड़ हो रही है. तो क्या करना चाहिए? उस बंदे के साथ बहुत बुरा करना चाहिए? अब देखो, बहुत इजी टॉपिक है, वेरी सिंपल, एक लाइन में आंसर खत्म हो जाएगा. ट्राइब्यूनल यस रिड्यूस कर सकते हैं पेनल्टी, एंड वो उसको नो सर्विसेज से रिड्यूस निकाल नहीं सकते. बट नाउ कंसिडर दिस एज योर एग्जामिनेशन क्वेश्चन, 4 marks question, And I'm waiting for your answers. I give you 2 minutes. At least try writing this answer, children, because we have to do some written practice so that you understand how important. So Tanu, Pooja, Manivanan, you all have mentioned it correctly, whistleblowing. So at least the provision part I would like to see. Don't write the facts of the case, don't write conclusion, but what will you write in the provision? That is what I want to see. Everybody write it down in the chat. One or two more questions we will do, and then after the break, we'll start foreign companies. Yes, Manivanan, it's whistleblowing, but I'm waiting for the provisions. All right, good, Kirti and Asta. So according to section 31, even if you don't remember, you can simply write down as per the provisions of LLP Act 2008, the court or tribunal may reduce or waive the liability against any partner or employee if it is satisfied that such partner has provided useful information during investigation or when any information given by partner or employee leads the LLP or any partner being convicted. सो क्या मतलब है अगर कोई भी पार्टनर ऐसी इंफॉर्मेशन दे रहा है जिससे इन्वेस्टिगेशन में ट्राइब्यूनल की कोर्ट की हेल्प होगी सो ट्राइब्यूनल विल हेल्प दैट. So on the basis of above provision, the question can be answered where the tribunal can waive off the liability imposed by it on Mr. J. Yes, tribunal has the power to waive off or reduce the penalty which is being imposed because it has provided useful information. First part, provision लिखे बिना आप conclusion नहीं लिखे. Okay? Can the LLP suspend Mr. J? This section further provides. अब आप चाहे ये conclusion में लिख लो, चाहे आप पहले ही दो provisions दे दो. What I would have been doing if I would have been at your place, I would write first the provision that tribunal can reduce or waive. Yes. And then I will say also the section further provides that no partner or employee will be discharged, demoted, suspended, or threatened or harassed against the terms and conditions of LLP merely because he has been provided. चाहे आप फर्स्ट पार्ट की प्रोविजंस लिखकर फिर उसका कंक्लूजन दे दो, फिर आप सेकेंड पार्ट की प्रोविजंस लिखकर फिर कंक्लूजन दे दो, वो भी ठीक है. आप दोनों पैराग्राफ्स में प्रोविजंस देकर फिर 1 and 2 कंक्लूजन कर दो, तब भी ठीक. What examiner is going to check whether you have written these points or not, then only you get marks. You simply write yes or no, you'll not get marks. Very good, Manivanan and Pooja. Meanwhile, you have written the answers, provisions correctly. Good. So J cannot be suspended just on the grounds that he is providing any vital information. Now, can J be suspended for any other reason? Suppose उसने कोई और गलत काम कर दिया, some mental harassment or any kind of fraud he has done at the organization. Can then Mr. J be suspended? Very good. Yes, ma'am. Why? Because merely because of this reason का मतलब होता है सिर्फ इस मुद्दे को उठाकर आप ये नहीं कह सकते कि अब हम उसे सस्पेंड कर देंगे, बट अगर वो इसके अलावा कुछ और करता है तो यस. मतलब डिस्क्लेमर का मतलब ये है कि सिर्फ इसमें प्रोटेक्शन ही ले लेनी आपको कि अब मेरे को कभी सस्पेंड करा ही नहीं जा सकता है, ऐसे नहीं हो सकता है. यू कैन स्टिल बी सस्पेंडेड फॉर एनी अदर रीजंस. Now, any doubts in LLP, because now we'll be starting with the foreign companies. Foreign companies is again very, very huge, children, so it will take time. Anyone wants to ask any doubts? Meanwhile, I'm just looking for certain more questions for all of you. Okay, one more question that I wanted to do with you. Everyone has written, ma'am, no doubts. That's great. Just a second. So let me show you another question. A dispute among the partners of LLP jeopardized the stability of the business. Out of the two partners, one due to a quarrel left the LLP. The other partner continued the business alone. You are an expert in law. You are requested to explain the provisions governing the LLP being operated by a single partner and its winding up by the tribunal under the provisions of LLP Act. It's a very, very simple question. Two things I'm looking for in this question. One is the time period, another is the provision. Varsha Chaudhary and all the others have given beautiful answers for the previous one. Okay, compounding of events. We will take it up, Varsha. Anyone would like to raise their hands and give me the answer for this one? It's very, very simple. Hand raise करके कोई आंसर करना चाहेगा क्लास में? Very good, Astha. Wonderful answer. If a partner alone doing more than 6 months, he will be liable for any liability. Almas, Varsha Chaudhary, all of you have given the correct answers. Manivanan, excellent. So the simple answer to this question is that if any partner is below, if LLP at any time have the partners below 2, then if it continues the business for more than 6 months, then that single partner will be personally held liable for the obligations. In the given situation, one of the partner is alone doing the business. Therefore, what is the answer which you have to give? What is the second provision that he's asking you? He's asking you whether the tribunal can do the winding up. So section 64 again, the circumstances, one of the circumstances in which the LLP can be wound up is if the number of partners have fallen below the minimum number limit. अभी करा था ना हमने section 64 में, so उसी provision को by laying stress on the same provision, you can say that yes, winding up is possible. यहाँ लिखा हो. If for more than 6 months the number of partners is reduced below 2, then yes, LLP can be wound up by the tribunal. So compounding of offenses, Varsha wanted to understand. So beta, first of all, what is the meaning of compounding an offense? Instead of having a harsh penalty, Sometimes law give you a reason that you can compound the offense. Means instead of going to a jail, your penalty will be increased in a more amount. So RD or any other officer, notwithstanding anything in the code of criminal procedure, पहले तो उसने disclaimer दे दिया, code of criminal procedure के कुछ भी आप खिलाफ नहीं बोल सकते. अगर आपने कुछ बहुत बड़ा crime कर दिया है, which is governed by the criminal procedure code, then there is no compounding offense. You will have to be going to the jail. But if it is not affecting that, then RD or any other person not below the rank of RD can compound the offense, which is punishable with fine only. पहला ऑफेंस वो कौन सा कह रहे हैं, किसको कंबाइन करना है आपने, जिसमें सिर्फ फाइन है. by collecting the suspected of having committed the offense a sum equal to the maximum fine, but it shall not be lower than the minimum amount. So जितना भी maximum fine है आप वो collect करो. However, nothing contained in this subsection, मतलब जो यहाँ लिखा है, it will not be applicable, shall apply to an offence which is committed by LLP within a period of 3 years from the date when the similar offence is committed or when he was compounded. So 2023 में आपने एक offence करा and RD के पास आपने application देकर उसकी compounding करा, ठीक है, you were punishable with fine only, there is no imprisonment and you got the compounding done. Now in 2024 you again committed the fraud. So it says nothing will apply to an offence which is committed within a period of 3 years. 3 साल में दोबारा कर दिया तो offence से आपकी compounding नहीं हो सकती. 2027 में करा, 3 साल पास हो चुके हैं, 4 साल बाद करा तो फिर से हो सकता. Any second or subsequent after the expiry of 3 years, then again it shall deem to be the first offence compounding. मतलब 3 साल बाद गलती दोबारा कर देना, but 3 साल के बीच में गलती मत करना अगर compounding करना. Application for compounding will be made to the registrar, will forward the same to the RD. पहले आप application registrar के पास लेकर जाओगे, वो RD को forward करेगा. Offence has been compounded, intimation will be given within a period of 7 days. So ये process बताया हुआ है, 7 days में आपने intimation देनी है. No prosecution shall be instituted. So very any offence is compounded before the prosecution. आपको जेल हो सकती थी, but आपने पहले ही compounded करा लिया, फिर आपको prosecution नहीं होगी, जेल नहीं होगी. Where the compounding is made after prosecution, आपको जेल हो चुकी है, then it has to be brought to the registrar in writing, notice of the court in which the prosecution is pending. The offender in relation to the offence so compounded will be discharged. Means आपको registrar को writing में देना पड़ेगा, आपको application लेकर आनी पड़ेगी, you have to inform. RD not below the rank of RD while dealing with the compounding may direct the partner, DP or any other person to pay the fees as may be required. Notwithstanding anything contained, if you fail to comply, then the maximum amount of fine which RD has ordered shall be twice the amount provided the compounding corresponding section in which the punishment was. So अगर आपका फाइन था इनकॉर्पोरेशन वाले में, उसमें 50,000 था तो आपका 1 लाख हो जाएगा. अगर आपका फाइन 10,000 वाली कैटेगरी में था, एनुअल रिटर्न नहीं फाइल करी तो आपका फाइन 20,000 हो जाएगा. जौन सा भी आपका फाइन, अगर आप कंपाउंडिंग ऑफेंसेस आरडी की प्रोविजंस को कंप्लाई नहीं करते हो, then your fine will get done. Simply you have to remember RD has the power. Compounding offense can be done before prosecution, after prosecution, given intimation to the registrar. 7 days time period has to be given, maximum amount of fine, and if any default is made, twice the amount of fine. Yeah. All right. All right. Thank you, Varsha. I'm glad you have understood and now you're finding it easy. That's great. Ishan, your answer was correct for the previous one. Yes, Astha, you have given section 2 also. That was great. Pooja, your answer was correct. So now let's begin with another new chapter. That is foreign companies. I hope no doubts left in this. We can move ahead to the foreign companies, and we have done a good revision of LLP. And I really expect all of you to write the answers the way we have discussed it in the class. Just give me 1 minute. I'm just reading if anyone has raised any query. So for companies incorporated outside India, I have certain question answers for all of you, which will be starting first, and then we will be going back to the revision also. Let me see where you actually stand out in case of foreign companies. So the first question in front of you on the screen is Z Limited, a foreign company which was incorporated in Japan, has a branch office in Hyderabad in India. Mr. Bharti, the Indian citizen, holds preference shares of Z, which comprises 10% of the paid-up share capital. Deshi Limited, a company incorporated in India, holds equity shares of Z Limited, which comprises 45% of the paid-up share capital. During the financial year 2019 and 2020, alteration was made in the particulars of the documents given under Section 380, and the company has failed to submit the alterations within 30 days. सब कुछ उसने बता दिया, आपको क्वेश्चन भी बता दिया, आंसर भी बता दिया. Please tell the applicability of the failure on the validity of the contracts and read the question very carefully. I have just taken your test without revision, just to understand where do you stand in foreign companies, so that I know how much extent of revision is required to be done. I'm waiting for your answers and then I will show you the answer. All right. So section 379, the simplest section after we have completed the definition of foreign company under section 2, clause 42. The simplest section, that is section 379, which tells us at least 50% of the share capital, whether equity or preference, or partly equity or preference of a foreign company is being held by one or more citizens of India or one or more companies or body corporates incorporated by India, then the company will comply with this provision of this chapter with regard to the Indian business. It will be treated as if it was a company incorporated in India. ये तो हमने लिख दिया provisions. Section 393 में हमने पढ़ा था कि failure by a company to comply with the provisions of this chapter 22 of the Act will not affect any validity of the contract. Therefore, while applying the above provisions, the provisions of Companies Act are applicable on Z because aggregate of 55% of the paid-up share capital are held. Therefore, provisions of Companies Act 2013 will apply on that company. It will be considered as an Indian. However, there has been violation of Section 380. The validity of the उससे 30 days में नहीं करा, उसने time period आपको बताया हुआ है. Validity of any contract will not be affected. Company may be sued for such contract, but will not be entitled to bring a suit in respect of such contract until it has complied with the provisions of companies incorporated outside. So this was a merger of two questions. 379 has to be applied. Ishan has written 379 beautifully. Chapter 22 will become applicable. Tanu has written. Almas has written. Excellent. Kirti has written. Kirti has written for the previous one. No, for this one. Is not less than. Yes, so it is 55%. So you have to give the correct provisions, child. Asta Sethi has not given for this one, for the previous one. Manivanan, again for the previous one. Understood, students? So again, section 379 is very, very important. Many a times question come related to this. But the interesting part was 393 was also made applicable for here. Yes, Pooja. So he has failed. This LLP, this company has failed to file the Alteration means there were certain provisions of Section 380 in which default has been. Now, 393 tells you that even if you have made a default, validity of the contract will not get affected by it. All right, students. So now I've come to know that you need good revision of foreign companies also. So let's take a small break here, and after the break, we will continue. Manish sir, we are taking a break here. back, students. Now we are going to have a quick recap of companies incorporated outside India. Although we have started with its question answers also. But still, I feel the need that we should revise the context first and then we will continue back with the question answers. So applicability in this chapter is basically we only have 3-4 sections only. That is section 2, clause 42. And then we continue. Please explain 386 who's required to authenticate the certificate. Okay, Shan, I will definitely explain you 386. Yes, Nidhi, good morning to the class. Welcome to the class and you will get all the PDFs, children. Don't worry. हाँ जी, so 379 है इसमें जो हमने अभी डिस्कस करा 380, 381 and then all the prospectus provisions that you have studied with us in Companies Act, similar provisions are applicable in foreign companies also. So what is foreign company? Company incorporated outside India having a place of business in India and you're conducting a business activity. Even if you're not having a place of business in India, then also if you conduct a business activity like Netflix, it is not having any place of business in India, but it is conducting business activity. So this and or has to be read in both the contexts. What is important is you have been doing business in India, whether through a place of business or online. Basically वो फिर online mode में cover कर देता है कि even if you're doing it by itself through an agent or through electronic mode and you're conducting any business activities like your Hotstar, your Netflix, they're not having any office in India, but they're still doing business activity in India, so it's a foreign company. Now, what is the meaning of electronic mode? Electronic mode means B2B transactions, means business to business transactions or directly business man are selling to the consumers, so business to consumer transactions, any data interchange is happening. If you are inviting or accepting deposits in India from citizens from India and from abroad, you're inviting and accepting them. What is the meaning of financial settlements? Any kind of settlements which you are doing for person abroad and for people in India, you're doing any financial settlements. Web-based marketing, Google जैसे आप यूज करते हैं उस पर आप मार्केटिंग कर रहे हो अपनी बाहर ने आपने कंपनी बनाई है बट इंडिया में आप उसको मार्केट कर रहे हो टेली मार्केटिंग कर रहे हो फोन पे बता रहे हो टेली मेडिसिन बता रहे हो कोई डॉक्टर है जो बाहर बैठा हुआ है मिस्टर जॉन एंड पीपल कैन कॉल मिस्टर जॉन एंड टेक द मेडिसिन इन इंडिया सो ही इज डूइंग ऑनलाइन बिजनेस इन इंडिया ऑल द data communication services. If any of these 6 services you are doing in India, you will be considered on social media, email, mobile, जैसे भी आप करते हो, you will be considered as a foreign company. Cloud computing से कर रहे हो तब. So there was a company, children, ABC LLC, which was incorporated in Singapore. And it was providing cloud computing services in India. But the main server was located in Singapore only. Can we say ABC LLC is a foreign company? Yes or no? Very good, Tanu. First one to give the answers. Manivanan. Everybody says yes, ma'am. Then also it's Asta Sethi. Very good. Ishan, what are you saying? It is not. Very good, Ishan. So whether the server is in India or not, it does not matter. As long as you're providing services in India. Ishan has written a query also. Ma'am, it is written company incorporated outside India has no place of business in India and employed an agent. Then it will not be a foreign. No. So if you are incorporated outside India, within India, either you are doing the business through an agent or physically or online, you will become a Foreign company. And once you're a foreign company, very good, Pooja, then provisions of this chapter will become applicable. Alma's correct. Everybody has given the correct answer. And if I have opened up a unit in IFSC Center, children, which has exemptions of SEZ unit, Special Economic Zone, can I be considered a foreign company? Answer is no, because IFSC is not considered to be part of India, so it will be exempted, so it will not be a foreign. Okay. Then section 379 we have already done. My question to the class is, do we only have to see equity or preference share is also included? Ma'am, both are included. At least 50% is held by Indian citizen or body corporate in India, or by both of them together. Then provisions of chapter 22 will apply to them. And for business carried on in India, it will be regarded as if it is a company incorporated in India. What is the meaning of body corporate? Body corporate is company incorporated in India as well as in companies incorporated outside India also. So अगर मैंने company बनाई सिंगापुर में and I'm doing business in Singapore only, is it a foreign company? I made a company in Singapore and I'm doing business in Singapore only. I have nothing to do. I'm an Indian citizen and I have made a company abroad. Pooja says no, ma'am. It is not a foreign company. Very good. Tanu says no. Almas says no. Very nice. So that's correct. If you have made a company, Nidhi says no. Manimanan says no. Very good. Varsha. So if I have made a company outside India, I'm doing a business outside India, it's not a foreign company, because for foreign company, I should be doing a business in India if I have incorporated a company outside India. Yes, for IFSC Asta, you have those exemptions. Now, my second question. Is this company a body corporate that I formed in Singapore and I'm doing business in Singapore only? Very good, Almas. Yes, it is a body corporate. फॉरेन कंपनी नहीं है, बट बॉडी कॉर्पोरेट इलैबोरेटिव कॉन्सेप्ट है. अभी जब मैंने एलएलपी कराया था तब भी मैंने आपको ये बात बताई कि बॉडी कॉर्पोरेट इज एन इलैबोरेटिव कॉन्सेप्ट. इज दैट क्लियर? नाउ दिस वन इज आल्सो क्लियर. 379 सिंपल बता रहे हैं कि जो इंडियन बिजनेस है, मैं एक सिंगापुर में कंपनी खोली है, जो दिल्ली में मैंने प्लेस ऑफ बिजनेस करा है जिसमें फॉरेन कंपनी है, अगर पेड अप शेयर कैपिटल 50% इन तीनों लोगों ने हेल्ड करी है या फिर जॉइंटली बॉडी कॉर्पोरेट या इंडियन ने, तो जो दिल्ली वाला बिजनेस है उसको ऐसे मान लिया जाएगा एज इफ इट इज अ कंपनी इनकॉर्पोरेटेड इन इंडिया. मीन सारी प्रोविजंस कंपनीज एक्ट 2013 की एप्लीकेबल होगी. सेक्शन 380 क्या कहते हैं? नेटफ्लिक्स का आप ऑफिस लेकर आ गए और आपने ऑफिस खोला पुणे में. Where do you need to submit the documents to the registrar? You're a foreign company. You have opened up an office in Pune. You're a company incorporated outside India, having a place of business in Pune. Where will you submit your all these documents? Full address, list of directors, name of the persons who are addressed in the authorized person. Okay, ये वाला point मैं आपको बताती हूँ अभी. Declaration that directors are not convicted. In which registrar? Delhi registrar. Very nice. Delhi ROC के पास जाओगे. ऐसे नहीं कि पुणे में खोला है तो पुणे के पास जाओ. ओके. Ishan is asking, ma'am, the question in MTP, it has not mentioned the company is not doing any business. So even if agent employed and not doing business, then we cannot assume that the business. ईशान बेटा, अगर आपने एजेंट, मैं अब सिंगापुर में रहती हूँ, मैं इंडियन सिटीजन हूँ या मैं फॉरेन सिटीजन हूँ, मैं सिंगापुर में मैंने एक कंपनी बनाई है क्लॉथ्स का सेल एंड परचेज करने के लिए, और मैंने दिल्ली में एक एजेंट एम्प्लॉय कर दिया. अब एजेंट एम्प्लॉय कर दिया बट वो काम नहीं कर रहा, सिर्फ एक एजेंट एम्प्लॉय करके रखा है, प्लेस ऑफ बिजनेस खोल दिया है बट वो काम नहीं कर रहा. इज इट अ फॉरेन कंपनी? Others also. I've employed an agent in India. I've opened up a company in USA. I've employed an agent in India. He's not doing any business activity in India. Neither online I'm doing, nor I'm having a physical place, but I'm not doing any business. Is it a foreign company? Very good, Asta. No. Nidhi says no. Excellent. It's not a foreign company. You have to be doing both the conditions I told you. सो और मत पढ़ो, एंड ही पढ़ो, बट कहने का मतलब ये था भी ऑनलाइन भी कर सकते हो, फिजिकल प्लेस नहीं है तो ऑनलाइन भी बिजनेस कर रहे हो तब भी आप फॉरेन। During process of incorporation, if any problem arises, can sue as foreign company for seeking a remedies. Yes, Manivanan, action can be taken, but no, it is not against the foreign company. I'll tell you against whom the action can be taken. First, Ishan, your point is clear, beta. Now, doubt is clear. And everybody else has answered beautifully. No, ma'am, it is not foreign company. Wonderful. Okay, good, Ishan. Santosh V, okay, good answers. Joined late, but yes, your answers are correct. Now, who asked the question? Manivanan. Manivanan, we have to give the name and address of the person who is resident in India, who is authorized to accept all the notices on behalf of foreign company. So there is a foreign company that we established in Singapore, ABC LLC. It is a foreign company because it is having a place of business in Pune. You are going to submit all these documents with daily hours. Now, when you are submitting all these documents, you will tell them that there is Mr. Ram, whom we have appointed as an authorized representative. He will be acting on behalf of our company. Now, this is the authorized representative, Mr. Ram, who has been given the name under section 380. His name is being given. Within 30 days of establishing the place in Pune, you are going to deliver all these documents with the ROC, and name of Mr. Ram will be given. So whatever action ROC or anybody else needs to take will serve the notice against Ram. And if Ram is the authorized representative, if he receives any notices, any complaints, or any action is taken, it will be assumed as if notice has been given to the foreign. Children, these सारी companies, LLPs, artificial judicial person है ना, they don't have legs to walk and talk. Somebody has to be authorized. वहाँ पे DP authorized करा था, यहाँ पे authorized representative. किसी को तो होल्ड करना पड़ेगा ना, अगर एक्शन लेने कंपनी के अगेंस्ट क्या एक्शन लोगे? यू हैव टू टेक एक्शन. यू कैन नॉट हियर, यू आर नॉट टेकिंग द एक्शंस डायरेक्टली अगेंस्ट द डायरेक्टर्स. यू हैव अ स्पेसिफिक ऑथराइज्ड पर्सन. सो मिस्टर राम इज द पर्सन जिसको सारे नोटिसेस सर्व किए जाए. एनी डॉक्यूमेंट विच द फॉरेन कंपनी इज रिक्वायर्ड टू डिलीवर, अभी हमने बात करी न्यू दिल्ली में देना है. If any, and what is the document, what is the form? Anyone remembers the form number? FC, which form? 1, 2, 3, 4. Section 380 का form number. Ishan, first one to answer. Almas, FC1, very good. And बेटा अगर कोई alteration हो गया, any business which is ceasing to exist, any new business that you have opened, list of businesses FC3 में, any alteration in FC2. FC2 is absolutely correct answer. Very nice, very nice. छोटा chapter है, 4-5 forms है, learn कर लिया. Okay. Any alteration again within 30 days. 30 days की provision 380 में है, alteration भी 30 days में फाइल कर. हो गया क्विक रिविजन. आरबीआई की कोई प्रोविजंस एप्लीकेबल हो अगर आपको फेमा में है तो वो भी आपने कंप्लाई करनी है. अबव इंफॉर्मेशन विल बी फाइल्ड इन FC1 एंड आल्सो प्लीज गिवन अ कॉपी दैट अगर आपने कंपनी खोली है ना इंडिया में तो आरबीआई अंडर फेमा विल आल्सो रेगुलेट इट. So when you will be doing the revision of FEMA, you must have understood about the role of Reserve Bank of India over there because you're doing business in India. You're using Indian currency. So RBI provisions also have to be, if approval, you have to file a document that approval has been taken from these authorized representatives. If any foreign company ceases to have, please give a notice that अब हमारा business नहीं है, now we are no longer existing, provided there is no other place of business. Section 381 किसकी बात करते हैं? Accounts of companies. Every foreign company will make a balance sheet and profit and loss account as per Schedule 3. CG will have the power to give the notice. अगर आपको consolidated financial statements banana hai with the foreign companies having a different financial year or calendar year, then also it can be made in the same form. But what is important, if it is not in the English language, now you have opened up a company in Germany, so you have used the language German, you made the financial statements in German. But जब ROC के पास जा रहे हो, do you expect ROC to know German, Persian, Russian, French? So much of knowledge you want the ROC to have? No, ma'am. We basically have the knowledge of English. So if it is not in the English language, a certified copy has to be taken. So we will do in the interpretation how the certification has to be done. As of now, a certified copy has to be. Certified means जब sign कर दीजिए कि हमने translation कर दिया, एक expert होगा जो certify करेगा इस document को, that yes, that expert will be having good knowledge about German language. He will check whether the financials have been translated properly, and then you submit that certified copy with ROC. ROC is not supposed to read German, and he doesn't need to find out whether it is right or not. Once authenticated copy has been submitted, he will file. And list of documents, I told you above, along all the documents, you have to give list of all the businesses in FC3. 3 form एक साथ ही हो गया. Documents related to consolidated financial statements also to be submitted. Now, along with this, what are the 3 important documents to be submitted with ROC? You have to tell me. What are the 3 important documents that are to be submitted with ROC? Very good, Almas. Repatriation of profits, related party transactions, and transfer of funds for the including dividends. So what is related party transactions? Any transactions that the foreign company is having between the related parties, referring to the provisions of preliminary chapter number 1, RPT transactions. Repatriation means जितना आपने profit यहाँ पे कमाया है और बाहर लेकर जा रहे हो, statement, how much profits you have earned in India and you're taking it outside India. Any transfer of funds. Transfer of funds and repatriation, what is the difference between them? Repatriation means taking directly outside India. Transfer of funds means how much you have distributed to the shareholders as dividend, and balance you are transferring to your own country. So these statements are important. And within how much time period these statements have to be filed? Within a period of 6 months from the close of financial year of the foreign company. फॉरेन कंपनी 31 दिसंबर को क्लोज कर रही तो उसके 6 मंथ से कर लेना, 31 मार्च को क्लोज करे तो उसके 6 मंथ से. What is the maximum time period for which this can be extended? What is the maximum time period for which the 6 months time period can be extended? Manivanan, 3 months. Very good. And what is the time period for annual return to be filed? 60 days from the close of financial year. वहां पे भी 60 days अभी करा था, यहाँ पे 60 days, same provisions जल्दी आ. What is the form number for filing the annual return? 4 forms एक साथ खत्म. FC1 registration, FC2 alteration, FC3 for list of businesses, and this one, last one form is FC4 for filing the annual return. Very good, Pooja. Nidhi, I'm liking your performance. You have really shown good improvement. No, Asta, penalties will not be necessary unless they have asked for. You can give a reference, that's correct. Provided you remember and write the correct section, Asta. Otherwise, avoid writing the sections. Be very, very sure about the sections, okay? So, provisions of Chapter 10. What was Chapter 10, children, under Companies Act? What was Chapter 10 under Companies Act? Audit and auditors. What was Chapter 9 under Companies Act? Accounts of companies. So कहता है वैसे तो provisions आपको 4-5 sections ही applicable है foreign companies में, but when we are doing section 381 under the accounts of companies, he tells you that entire chapter number 9 accounts of companies is applicable to foreign companies, and entire provisions of chapter 10, that is audit and auditors, is applicable to the foreign companies. Then display of name is very simple. I don't think we need any kind of revision in that. Simply you have to display your names around the bill heads, letterheads, all these places. And to whom the document has to be served? Any person whose name and address has been delivered to the registrar under section 380. अगर इस बंदे को आपने नोटिस एंड डॉक्यूमेंट सर्व कर दिया, कैसे सर्व करना है? या तो उसके ऑफिस के बाहर छोड़ दो या एड्रेस पे पोस्ट कर दो. So it will be considered that the document has been served on the foreign. क्वेश्चन आ सकता है एग्जाम में, मिस्टर राम को डॉक्यूमेंट मिला, फॉरेन कंपनी ने कहा मेरे को तो कोई नोटिस नहीं मिला. कैन फॉरेन कंपनी डिफेंड? The answer is no, because the notice once given to the authorized representative will be considered as the notice served to the company. डिबेंचर्स, एनुअल रिटर्न, फिर वही वाली बात है, कहते हैं सेक्शन 71 अप्लाई कर देना। सेक्शन 71 क्या था बेटा, कंपनीज एक्ट में, इशू ऑफ डिबेंचर्स। 92 क्या था, एनुअल रिटर्न वाला। सेक्शन 135 क्या था, सीएसआर पॉलिसी। 128 अकाउंट्स ऑफ कंपनीज में अभी पढ़कर हटे हो, बुक्स ऑफ अकाउंट। चैप्टर 6 रजिस्ट्रेशन। चैप्टर नंबर 14 जो कि आपका सीए पैनल में आता है, इंस्पेक्शन इंक्वायरी, ये भी सारी म्यूटेटिस म्यूटेंडस अप्लाई हो जाएंगी टू एनी फॉर। कहते कहने को 3 सेक्शन ही है, बट सेक्शन 384 में उसने बता दिया कि सारे सेक्शंस जो कंपनीज एक्ट में है इसको भी अप्लाई हो। Interpretation. Certified means certified in such a way as a true and correct copy. So somebody was asking certification. So whosoever is an expert in that language, it has to be certified by that person, and it will be considered that it is a true and correct translation. Director means according to whose instructions you're acting, and place of business includes share transfer and registration office. Very, very important. I formed a company, ABC Company Limited in USA, and I have opened up my share transfer office in Delhi. Can we say ABC is a foreign company? Yes, ma'am, or no, ma'am? Very good. Yes, ma'am. Pooja says no. Why no, Pooja? अगर आप शेयर ट्रांसफर या शेयर रजिस्ट्रेशन ऑफिस भी अगर इंडिया में खोलते हो तब भी आपको फॉरेन कंपनी मान लिया जाता है। गुड तन। सो पहले बेटा फिजिकल ट्रांसफर ऑफ शेयर्स होता था ना, तो लोगों को अपना ऑफिस खोलना पड़ता था। अब तो ऑनलाइन हो जाता है, तो अगर आपने शेयर ट्रांसफरिंग के लिए भी ऑफिस खोला हुआ है तो माना जाता है कि आप फॉरेन। Now, whenever I come to this topic, it takes me into the memories of chapter number 3 of Companies Act. What is chapter number 3 of Companies Act, children? I'm forgetting. Can anyone tell me the name of chapter number 3 of Companies Act? Prospectus and allotment of securities. कितनी elaborative तरीके से हमने prospectus पढ़ा हो. So when we come to foreign companies, it is so simple, children. सिर्फ 2 चीजें लर्न करने वाली है। 379 की प्रोविजन नहीं है, डेफिनेशन नहीं है, 380 के डॉक्यूमेंट्स थोड़ा बहुत पढ़। 30 days, 30 days, 60 days, सिमिलर से नंबर ऑफ डेज है, 4 फॉर्म्स है। Very easy and simple chapter. I don't want you to lose single mark on LLP and foreign company at least. Because children, when we do the revision, even if you spend 1 hour on this chapter, now you are done. Trust me, you are done. And I'm going to do, we still have 1 hour left. I'm going to do so many questions with you. You keep answering me back, you keep doing your writing practice, आपका chapter वैसे ही रहेगा. All right, I hope you're enjoying the revision, students. All right, good. So one more topic to go and then we will be starting the question answers. So everybody has answered it correctly. Okay, thank you. Nidhi says it's very interesting, ma'am. So that's great. So prospectus, जैसे हम इंडिया में कंपनी पैसा लेने के लिए prospectus इशू करती है. Now you're a foreign company and you want to raise money from people in India, you will have to issue a prospectus. It contains the particulars relating to the constitution of the company. Company बनाने के लिए जो document होता है वो MOA, AOA होता है. Similarly, it is known as the document. Constitution of the company means which has all the details about what is the company, what is the name of the company, how it was incorporated, all these details. Enactments and provisions under which this. So अगर आपने US में कंपनी बनाई है तो उसको कौन सा एक्ट एप्लीकेबल है, जर्मनी में कंपनी बनाई है तो उसको कौन सा एक्ट एप्लीकेबल है, सारे डिटेल्स आपको देना. एड्रेस देना है कंपनी का. अगेन इफ इट इज नॉट इन इंग्लिश लैंग्वेज, यू गिव अ सर्टिफाइड कॉपी ऑफ ट्रांसलेशन. सो 2 जगह आपकी सर्टिफाइड कॉपी यूज होगी, एक सेक्शन 380 में, एक सेक्शन 387 में, when you're submitting the documents for prospectus. Date and the country in which it was incorporated, and the company has established a place of business in India. What is the address of that place of business? Matters to be given under section 26. उसने फिर कहा ठीक है, बाकी सारी चीजें सेक्शन 26 को रेफर कर लो, आपको आती है, वो सारी भी इंक्लूड कर. Whatever SEBI tells, so I've given you a brief line over here, just a hint. Whatever SEBI tells you, whatever the documents and section 26, वो सब इंक्लूड. But children, point number 1, 2, and 3 will not be applicable if the prospectus issued is more than 2 years after the date. अब ये important है. पेपर में केस स्टडीज के ऊपर आई. एबीसी एलएलसी थी, फॉरेन कंपनी थी, सिंगापुर में बनी, इंडिया में प्लेस ऑफ बिजनेस है, 2020 में बनी है, प्रोस्पेक्टस इशू करने जा रही है 2025 में. कौन से 3 डॉक्यूमेंट्स उसको नहीं सबमिट करने? What are the 3 documents which are not required? MOA, AOA देने की जरूरत नहीं है, under which incorporation you have been formed, and address की certified copy देने की जरूरत नहीं है, क्योंकि आपको 2 साल से ज्यादा हो गए. अब हम आपको जानते हैं, ये कंपनी के बारे में हमें नॉलेज है. So if 2 years have been passed after the date when the company commenced the business, then in case of prospectus, 1, 2, 3 points will not be applicable. Clear, students? Okay. Dating of the prospectus, so compliance cannot be waived by any omission. And again, the provisions of prospectus under foreign company will not be applicable in 2 cases. What are those 2 cases? If you're issuing to the existing debenture holders or existing shareholders, and as far as the prospectus is issued, the securities are uniform for the securities previously issued. आपने A listed equity shares पहले भी list करा था, उन्हीं की listing के लिए दोबारा कर रहे हो, then it is not required. Okay. All right. Thank you, Manivanan. I'm glad you're liking the revision. That's great. And everybody has answered this one also correct. Provision for experts consent. Anybody would like to tell me section 388? It's very, very simple. You have revised it under chapter 3 also. Raise your hands and answer me. Let's make the class a little more interesting. Khushi Gupta, Ishan, Tanu, Pooja, who is going to raise their hand and give me 3 important points related to section 388? That is experts consent. You would like to answer me by raising hands, or you would like to chat box? You would like to use the chat box? Yes, Pooja. Would you like to speak? Experts consent. Asta Sethi, Kirti, Almas. Yes, Pooja.
Ma'am, in a case of expert consent, expert has been consented, and he has not withdrawn their consent, and
a declaration and filing that the consent of the expert, a written consent has to be taken. He has given it before the delivery of prospectus, and a declaration to the consent that this consent that he has given has not been withdrawn. Very good, Pooja. Excellent. So everybody has written in the chat box also. That's absolutely correct. So expert consent वही वाला point है. आपको वो same question foreign company का बनाकर पूछ देगा. Points remains the same, but you have to give elaborative points related to this. So wherever the statement is including an expert consent, written consent has to be taken, and it should not have been withdrawn. It shall appear in the prospectus a statement that he has given and not withdrawn. Where the application is made according to the provisions rendering all the provisions of section 33, that is issuing the application of securities, and section 40 will also become applicable. A statement to be included in the prospectus if it is contained in any report or memorandum incorporated there. So all these points are very, very similar to chapter number 3. So you'll remember that and write it down. Section 389 deals with, again, signing and delivery of prospectus. Who will sign it? At least certified by the chairperson, who are the directors of the company, approve the resolution. On the face of it, it should be written that the copy has been delivered, and any consent of the issue of prospectus required may be. So very, very simple provisions. All the documents to be attached with the prospectus. What are the 5 documents to be attached? Section 389. Consent that it has been taken from the expert. Copy of contracts. Any other material contracts not entered in the ordinary course but entered within the proceeding. within 2 years अगर आपने कोई contracts enter करे which are not the ordinary course, कोई extraordinary material contracts, copy of underwriting, power of attorney if it shall be signed by the agent. And then we come to almost last section, that is 390, Indian depository receipts. Now this is again given much detail, but again, if you refer to GDRs, when I did chapter 3 with you, similar kind of provisions we have discussed over there. That GDRs is when you're raising money abroad, you're an Indian company and you're raising your GDRs abroad, then you'll go to the custodian bank. The custodian bank will inform the depository overseas bank that the now Infosys has given us their shares, please raise the GDRs over there. Similarly, IDRs इंडिया में रेज हो रहे हैं, डोमेस्टिक डिपॉजिटरी के पास इंफॉर्मेशन आएगी कि बाहर वालों ने हमें इंफॉर्मेशन दे दी है कि अब आप आइडियाज इशू कर दो. आज तक सिर्फ स्टैंडर्ड चार्टर्ड एक ही आइडिया आया है, but it is just giving you the banner under 390 how the ideas can be issued. So foreign companies merge with the companies registered prior to approval of RBI has to be taken. All these kind of provisions, you can simply give it a read. Application of section 34 to 36. क्या था बेटा 34 to 36? Misstatement of prospectus. If it is incorporated outside India, issuing of prospectus, they will become applicable to it as if it is an Indian company. Issue of IDRs. Same provision of section 34 to 36 will also be applicable. Punishment for contravention under 392. Asta was referring to this punishment. Definitely, if any contravention has been done by defaulting foreign company, you can write this to a penalty also 1 lakh to 3 lakh rupees. If the penalty continues, 50,000, and for any defaulting officer, 25,000 to 5 lakh. एक या दो penalties है पूरे chapter में, learn कर लेना please, बहुत important penalties. No imprisonment children. Imprisonment कहाँ पड़ी थी हमने? LLP की incorporation में false दिया था तो 2 years की imprisonment. Company's failure to comply with the provisions not affect the validity of contract. ये मैंने आपको case study का question कराया था section 393 का. Any contract transaction entered by the company, its liability to be sued in respect therefore. Company shall not be entitled to bring any suit, claim any set of institute any legal proceedings until it has complied with the provisions of Companies Act. आपको कुछ भी वैलिडिटी ऑफ कॉन्ट्रैक्ट से रिलेटेड आता है, आपने ये दोनों पॉइंट लिख कर आने कि जब तक आप कंपनीज एक्ट के प्रोविजन से कंप्लाई नहीं करोगे, कंपनी केस फाइल नहीं कर सकती है. बट कोई भी कॉन्ट्रैक्ट जो कंपनी ने करा है उसके लिए उसकी लायबिलिटी रहेगी. इट विल नॉट अफेक्ट द वैलिडिटी ऑफ द कॉन्ट्रैक्ट. Exemptions have been given by central government respective cases. That is something you can explain. Rule 12. Okay, Asta, we will open the study material and we will refer it from there. Any other students having any doubts? Because now I'm going to ask you questions. So rule 12 simply tells you about the investigation. I'll explain you. Action from the improper use or description of foreign companies. It states any person who is carrying on any business under the title of foreign company, then those persons, unless duly registered, shall be liable for investigation under section 210 and action will be taken against. Now, what is he trying to tell you? I formed a company, ABC Limited, in Delhi. And I'm trying to make improper use. I said this is a foreign company. Children, I formed a company in Delhi and I'm saying it's a foreign company. Am I correct in saying that? क्या मैं ठीक कह रही हूँ कि ये फॉरेन कंपनी? No, ma'am. Good. Why no? Because, ma'am, foreign company, you have to incorporate a company outside India and have a place of business in India. ऐसे कैसे आप कह सकते हो? या फिर मैंने कहा मैंने कंपनी दिल्ली में बनाई है और उसकी ना ब्रांच ऑफिस सिंगापुर में. So having a subsidiary or holding relationship, then it is fine. But if I formed a company in India and it is doing business in India, it has no connection with outside India, then I'm using wrong name. I'm using improper use and describing a foreign company just to claim certain exemptions. Person is trying to do that. फिर क्या हो जाएगा? मेरी इन्वेस्टिगेशन हो जाएगी अंडर सेक्शन 210, जो कि आपके सीए फाइनल का सिलेबस है. उसने बताया ही नहीं है सेक्शन 210 में इन्वेस्टिगेशन कैसे होगी. बट एग्जाम में क्वेश्चन दे देगा 2 मार्क्स का, एबीसी लिमिटेड ने कंपनी बनाई दिल्ली में एंड ही सेइंग It is a foreign company. Is it a foreign company? Yes or no? Please tell. And what are the consequences? ये छोटा सा पैराग्राफ लिख देना रूल 12 का बता देना that no, it is not a foreign company. Any person or the persons who are dealing with that, unless it is a foreign company, they will be liable for investigation under section 210 and actions will be taken against that person. Clear, Asta? समझ आ गया बेटा? Everybody else is also clear about this? Please explain 111 provisional time limit. Pooja's question. Pooja, please refer to the page number which you're talking about. (388) part B. Okay, I'll explain you. If the prospectus does not have the effect where the application is made, you remember children section 33 and 40? If the prospectus, first of all, it's saying no person will circulate the prospectus unless statement wala point aa gaya. Okay. If the prospectus does not have the effect where the application is made for rendering all the persons bound by the provisions of section 33. Refer to section 33, issuing the application form has to be given along with the prospectus and for the securities to be dealt in stock exchange. Section 40 kya kehta tha? That you have to tell whether you're listing the securities on National Stock Exchange or Bombay Stock Exchange, whatever the securities are there, you have to give it. A statement shall deem to be included if it is contained any report or memorandum on the face of it. So on the face of it, जैसे हम वहाँ पे include करते थे, यहाँ पे भी on the face of it, you have to include the details. Page number 7.64. 7.64. We are on chapter number 11, beta. Pooja, you're asking with reference to some other chapter that we will take up later on. First, we have to complete our syllabus that is assigned to us for today. Now you have nicely revised LLP. उसके questions भी हो गए, foreign company भी हो गया. अब आपका testing time है. We have 40 minutes, and in this 40 minutes, we are going to do elaborative question answers for 40 minutes. Anyone still have any doubt in foreign companies? Please ask your doubts. Because now we'll be starting with the question answers. इंटरप्रिटेशन का क्या मतलब होता है? निधि इज आस्किंग बेटा, इंटरप्रिटेशन का मतलब होता है कि आपने लॉ को कैसे इंटरप्रेट करना, कैसे समझना है. इंटरप्रिटेशन का मतलब ही लॉ जो हम पढ़ते हैं हम उसे इंटरप्रेट करते हैं ना. जैसे वहां पे लिखा हुआ है दैट दिस शैल नॉट बी एप्लीकेबल, हिंदी में इसका मतलब हो कि ये आपके लिए एप्लीकेबल नहीं हो. तो इंटरप्रिटेशन स्पेसिफिकली फॉरेन कंपनीज में उसने 3 चीजों के लिए दिया है कि डायरेक्टर कौन होएगा जिसकी इंस्ट्रक्शंस पे आप एक्ट कर रहे हो, प्लेस ऑफ बिजनेस में शेयर ट्रांसफर एंड शेयर रजिस्ट्रेशन ऑफिस भी इंक्लूड कर लेना. मींस अगर आपने कंपनी खोली है बाहर और यहाँ पे सिर्फ शेयर ट्रांसफर ऑफिस है तब भी आप फॉरेन कंपनी हो. एंड पॉइंट नंबर 1 में वो बताता है सर्टिफाइड का मतलब क्या है कि अगर आपने बाहर की कंपनी रशिया में हो तो रशियन लैंग्वेज में आपने फाइनेंशियल स्टेटमेंट्स बनाए. बट क्या निधि आरुषि को रशियन आती है? आ भी सकती है, नहीं भी आती, बट आपको एक सर्टिफाइड कॉपी लानी है. तो कहते हैं इंटरप्रिटेशन का मतलब बता रहे हैं क्या मतलब है कि क्या कैसे इंटरप्रेट कर. ठीक है, ऑलराइट, गुड, अंडरस्टूड. And I can see that there are no doubts in foreign companies. Everybody is geared up and ready for the test now. So here comes question number 2 in front of you on the screen. TransAsia Limited is registered as a public company under Section 4, Clause 7 of the Erstwhile Companies Act as a subsidiary. Okay, this one as of now. Let's do this. Mr. Zian, an Indian citizen, holds 25% of the paid-up share capital of Laurel Stephen Limited, a company which was incorporated in Singapore, having a paid-up capital of 10 million Singapore dollars. Swaraj Limited, a company registered in India, holds 30% of the paid-up capital of Laurel Stephen Limited. It has recently established a share transfer office in New Delhi. What are the formalities to be observed? Read the question very carefully and everybody is going to answer this one. It's a very, very simple question. And I expect that you don't cheat from the book and answer. Yes, section 380 is correct, but you have to tell them what formalities are to be observed. And read the provisions of the paid up share capital. That is also very important. Yes, very nice. Astha, everybody else, I'm waiting for your answers. Excellent, Almas. Okay. So everybody has got the hint. 380 was to tell you about the requirements, but what is the major requirement? First, you have to define. First, you have to define the definition of foreign company. Then simply give 379. देखो बहुत favorite है 379 examiner का. Many a times you keep getting question out of this. 50% of the paid up share capital held है. यहाँ पे उसने साफ बता दिया Lawrence Stevens Limited. See, this is a very beautiful explanation of the answer. This is how I expect you to write. Provisions लिखनी है पहले. फिर facts of the case. नीटनेस होनी चाहिए आपके आंसर में बेटा. आप आकर बोलोगे मैम मैंने अंडरलाइन करा, मैंने सब कुछ बताया, बट जो बात कहने वाली थी वो कही ही नहीं मैंने आंसर में. बात नहीं मैंने. Laurent is having a place of business in New Delhi. Obviously, it's a foreign company. Its shareholding is 25% held by Mr. Zian, who's an Indian person, and 30% by Spraj, which is an Indian company. Together, they are holding 55% of the share capital. Percentage दिया ना बेटा, 379 apply कर. Although it is a foreign company, but due to holding of more than 50% by two Indian entities, it will be covered in the 379. And for the Indian business, it will be treated as an Indian company. However, under section 379, application will only be in respect of the business carried on in India and not for the business anywhere outside India. It will be application of Companies Act 2013 कहते सारा का सारा कहाँ पे लगेगा for the Indian business. And then foreign company is required to submit following documents: certified copy of the instrument, full address, list of directors, and सारी information आपने उसको दे देनी है जो कि आपकी section 380 की information है. Authorized person, representative, opening and closing place of business, directors are not debarred or convicted, and name and address of person, one or more persons resident in India. Please remember that person should be resident in India, of whose authorized representative is named that. ठीक है बेटा. Yes, within 30 days also you will give money, Vanan. That's good. So when I was checking your answers, I have seen most of you have just given 379. You did not give the documents of 380. ऐसा क्वेश्चन 4 to 5 मार्क्स में आएगा तो आपको फुल फ्लेश्ड आंसर लिख कर आना है. Okay. Now here is the next question in front of you on the screen. Read it very carefully and give the answers in the chat box. Yes, ma'am, it is a similar one. That's great. Please make sure what is the exact provision. More than 50% or 50% exact. I want you to tell me that. इसमें मैं सिंपल आपसे एक्सपेक्ट कर रही हूँ यस एंड नो बता दो. Pooja says no. Ishan says yes. Nidhi says yes. Reason? In the case, although company was incorporated, its share capital of not less than 50% is there. What is the word, children? Not less than 50%. Not less than 50% means equal to or more than 50%. Therefore, Chapter 22 will be applicable. Within 30 days, you have to file. Again, all those copies, a certified copy has to be filed. Even with 7 articles. And in the given case, company has established its office on 15th January 2021 and it is required to file the documents latest by 14th February 2021. उसने आपसे डेट मांगी है, इस पर डेट दे देना. अगर 2 साल ठीक है, so simply you have to give the 30 days. Yes, it is deemed to be an Indian company. Very good. Tanu and Shan and Vrishta go. Pavan Kumar, correct answer. All right, let's do the next one. Qinghai Holding Industrial Company Limited, incorporated in China, established a place of business in Mumbai. The charter documents constituting the company in Mandarin Chinese, so the Chinese local language, Mandarin. It is required inter alia to file a certified translation of the above documents with the ROC. Who can authenticate the translated charter and characters as per the provisions? Where government companies. So Ishan, here is your answer. Who will translate it? How the translation has to be authenticated? It is clearly given. All the documents required to be filed. If it is not in local language, if it is not in English language, a certified copy has to be given. It's given under Rule 10. And if such translation is made in India, it will be authenticated by the advocate, attorney, or pleader which is appearing before High Court, or the affidavit has to be taken from the person who is having an adequate knowledge. मैं आपको बोल रही थी ना, expert जो होता है जिसको adequate knowledge है, उससे आपने एक affidavit sign कराना है कि हाँ जी मैंने इसको convert कर. And or advocate हो सकता है High Court का या attorney lawyer हो सकता है. In the instant case, it can translate the related documents within India and will be authenticated by any of these persons. So please children remember this. Translation made within India, outside India के लिए दूसरा बंदा है. If the translation is made within India, it has to be authenticated by any of these. Again, this is learning part which you all have to remember and learn. So I think let's take a 2 minutes break. I want you to just go through the chapter because we have 3 more technical questions. So we are taking a small break here for 5 minutes. Yeah, 5 minutes. Actually, I'm a little unwell also today. All right, students, welcome back. So now you will have a conceptual clarity of the questions that I wanted to do with you, which is again a very, very important base question. So ready for questions, students? Yes? All right. Everybody has given a good positive response. Let's move ahead then. So analyze under the provisions of Companies Act 2013 whether the following will be considered as a foreign company or not. So one by one, we will be reading all the cases. A company was incorporated and registered outside India in Moscow, Russia. It has installed its main server in Moscow for maintaining office automation software by client cloud computing for its clients in India. Who will tell me for the first case whether it is a foreign company, yes or no? Please mention server is not in India. Will it have any impact? Manivanan, first one, Ishan, good. Pooja, good. Astha, Almas, everybody has given the correct answer. Yes, it's a foreign company. Main server within India or not India will not impact. ये line लिख कर आनी बेटा, whether it is in India or not in India, it will not impact. How will you do it? I will show you the definition. A company incorporated outside India employs an agent in India but has no place of business in India. आ गया ईशान आपका question. It is a foreign company, yes or no? Pooja says no. Varsha says no. Ishan says no. Reason क्या लिखोगे? Assumption क्या लिखोगे? Manivanan, are you saying yes for this one? It's no. This one. Asta says no. What will be the reason? You have to tell them, even if it is having no place of business, we are assuming that you are not doing any business in it. So employs an agent and does not have a place of business in India as per Section 2, Clause 42. Any company incorporated outside India has a place of in India, whether by itself or through agent physically, and is doing business in India. The company has employed agent but have no place of business cannot be termed as a company. You simply have to tell them that you're not doing any business in India now. Okay. A company formed outside India, registered in Australia, has authorized Mr. X in India to source customers and subsequently enter into contracts on behalf of. What is happening in third case? If you say, ma'am, yes, it's a foreign company, why? I want the reason. The third case, it's foreign company. Yes, ma'am. What's the reason for that? Very good, Pooja, for the previous one. Correct explanation. Good, Kirti. Your answers are coming and correct answers. For the third one, I'm waiting for the reason. Anyone would like to raise their hands and give the reason? Yes, Tanu. What is the answer for the third one? Asta Sethi has raised her hand. Yes, Asta.
It is a foreign company. As it has entering in the contract, so it will be regarded as doing a business activity in India and also have the agent appointed. So first condition is also satisfied.
Very good. Excellent. Excellent. Yes, Tanu, you would like to add something?
Yes, ma'am. Mr. X is acted as the agent, so it is a foreign company.
Very nice. Very nice, students. Your response makes me feel so proud that you have understood it nicely, and this is how you have to write in the exam also. I will show you the answer for this one. You simply have to tell them that it is in Australia, X is acting as an agent, it has place of business in India through an agent physically and is conducting business activity. ये जरूर बता कर आओ बेटा. उसने कहा ना सेल परचेज कर रहा है, एंटर कर रहा है कॉन्ट्रैक्ट. बिजनेस एक्टिविटी हो रही है, इस करके वो फॉरेन कंपनी माना गया. सेकेंड एंड थर्ड में डिफरेंस समझ आ गया सब बच्चों को? फोर्थ वन, read the question and raise your hands. Let's make it interactive. It's last 15 minutes left, and then you will be gearing up for your exams. So last class and last 15 minutes, let's make it interactive. Fourth point, read it and raise your hands. Company is in Mauritius, business strategies, everything is being carried in it. Yes, Ishan.
Good morning, ma'am.
Good morning.
Even though this company is satisfying the first condition, that is incorporated outside India, but mere business meetings and strategies meetings are conducted in India, cannot be considered as having a place of business in India or conducting a business operation in India. So it is not a foreign company.
Unless and until it would have been doing any business activity in it.
Yes,
Very
ma'am.
good. Excellent, Ishan. Beautifully elaborated. And I like the word mere business meetings in India. So simply you're having a business meetings in India and you're concluding, then that is not applicable. Mere holding of meetings and executing business models will not be considered as business activity. So above it is not a foreign company. I hope, Tanu, you also wanted to say the same answer. So everybody is correct, even in the chat box. Varsha Chaudhary, everybody, Manivaran, everyone has given the correct answer. Now let's move to another question. Xinc is a company registered in UK and carrying the trading activity with the principal place of business in Chennai. Since the company did not obtain registration or make arrangements to file the return, GST officer wants to serve show cause notice on the foreign company. As standing counsel for the department, advise the GST officer on valid service of notice. Very, very simple question. पढ़ लो एक बारी दोबारा फिर आंसर. Raise your hands for the answers. Yes, Pooja.
In this case, ma'am, the GST officer can send notice to authorized person as mentioned in section 380. The notice sent to that person will be deemed as notice is sent to the foreign company.
Very good, beta. Very good. Nice. Good answer. Anybody else would like to try? Section 383, you remember or not, it's okay. So serving of the notice, according to section 383, any notice, process or document served shall deem to be significantly served if it addressed to the person who is named to the registrar under section 380. If it is left or sent by post, here GST officer may serve the notice according to the above provisions. Assumptions, it is assumed that it is a foreign company within the meaning of section 379 of the Companies Act. उसने ये भी बता दिया कि हम मान रहे हैं कि ये foreign company, it is doing trading activity ना, did not obtain the registration or make arrangement, so we are assuming. उसने नहीं कहा foreign company, उसने तो कहा UK में बनी and business चेन्नई में करे, तो उसको बता भी देना as per section 2 clause 42, it is a foreign. Let's do this question. Phil Health Systems Incorporated. बेटा अगर आपको ये सारे questions का answers खुद से आ रहा है देना, and even if you're not able to, but you're able to correlate and understand, then give yourself nice patting on your shoulders. That means you are very well versed with foreign companies, because these are all jumbled up questions. In fact, the first one was so jumbled up that you had to go to section 393, which is the last section of this chapter. So if you are being able to answer these questions, that means your preparation is going really, really well. I keep telling you, children, in intermediate law is not just about learning, it's about attempting the questions, and you should be thankful to the institute that they are making so much effort for all of you, that they are making and helping you to revise each and every concept. Now it is your time to showcase and give a good exam so that we all can feel proud of you. As much as writing practice you can do, please do it, keep on doing. And one tip I want to give you on the before you go for your final exam, please make sure that you flip all the pages of the chapters. कई बार हमें लगता है कि हाँ यार मैंने तो उस दिन क्लास में सारे फॉरेन कंपनी के आंसर करे थे तो मुझे अब ये रिवाइज करने की जरूरत नहीं है. नो, एटलीस्ट एग्जाम से एक दिन पहले ना देखने जरूर है सारे. जस्ट फ्लिपिंग एंड आई फ्लिप. जब कुछ नहीं याद आ रहा है तो उसको थोड़ा सा टाइम लगा के लर्न कर लेना. एक्सपर्ट्स कंसेंट वाला जैसे आपको बहुत अच्छे से आता है तो उसको पूरा नहीं पढ़ने बैठना उस दिन. जस्ट रीड इट एंड देन मूव ऑन फॉर. ओके, but when you sit for the exam, everything will be here and it will keep coming back to your mind. So just remember this thing, that ek din pehle at least flip through the entire syllabus. That is very important. Because sometimes we get overconfident, we feel that yes, we remember everything, but the syllabus is so huge that yes, it's a normal human error. We do tend to forget. So quick revision and recap on one day before will really help. All right. Okay. So Phil Health Systems Incorporated is a foreign company registered in Australia, having a place of business in India. The financial statements of Section 381 bhi kara diya usne. Financial statements filed on 31st March 2020, prepared by the company, referring to the provisions, advise the company on the following matter. Whether the accounts pertaining to Indian business operations shall be audited by yes, then who? Who is going to answer the first point? No, Asta, you're only supposed to use black pen and you can underline also using the same pen. Okay. Yes, Ishan.
Yes, ma'am. They have to get their accounts audited only by a chartered accountant who is in practice in India, or a firm of chartered accountants.
Or a firm or LLP
LLP.
of practicing chartered accountants. Very nice. Very nice. Okay, thank you. Who is going to answer the second one now? When is the due date for filing the audited financial statements with the ROC? ये सारा हमने पढ़ा है अभी थोड़ी देर पहले. Manivanan, okay. Good, Ishan, for raising hand. Yes.
The company has to file an annual return within 60 days. He has to file within 6 months to ROC. If there is a delay not filed, 3 more months they will extend.
Excellent. Even without asking if there is any delay, you have answered it. So beautifully answered, child. 6 months and extension can be given for 3 months. Very good. Who is going to answer the third one? What is the effect of the contracts entered by Indian company in case they have not filed the financial statements with the ROC? Who is going to answer the third one? Okay, Astha.
Here section 393 comes into play and all the contracts will be valid and not be regarded as invalid due to the company has defaulted.
And you will also write non-filing of the financial statement, like you said, will not invalidate the contract. However, PHSI will not be entitled to bring any suit, claim set off, counter claims until the company has complied and filed with the financial statements. Well done. Well done. Well done. And the fourth one is very, very simple. Who is going to answer me the fourth one? Almas.
It must file in Form FC4 within 60 days.
Very nice. Excellent. The return has to be filed in FC4 along with a period of 60 days from the last day of financial year. That is 30th May 2020 to the registrar containing the particulars as we have done in the financial years. Clear? Everyone is clear? Interesting question and very, very simple question. Very scory question. You want to do 1 or 2 questions more? Or it's enough practice? If you want, I have 2 more questions if you want to practice. Yes, ma'am, we want to practice. That's great. More, ma'am. Tanu says more, ma'am. Yeah. And all these PPTs will be uploaded. All these question answers assignments will also be uploaded on the portal. So you can refer to them for your revisions. Tokyo Ferro Alloys Limited, a company registered in Japan, started its operations in India, established a marketing division in Mumbai on 1st April 2021. The company is planning to issue certain securities and want to circulate in India prospectus. What all the formalities are required? Advise the person in charge of Indian operations regarding the other documents which are to be required to be filed in respect of the prospectus. Now, this is very, very simple. 387, 388 will going to come into picture. So tell me what you can recall with respect to prospectus. They have not given you the date for the 2 years time period. Otherwise, that 2 years point would also have become applicable. I'm waiting for all your answers. Would like to give the answer for this one? Okay, you're writing in the chat box. All right. So again, all those points of section 389 will be covered. Any consent required from the person as an expert, copy of the contracts for the appointment of managing director, copy of other material contracts. I told you 2 years time period, it should be more than that. Any underwriting agreement and copy of power of attorney. Simple section 389 answers you have to give. 387 would have been applicable if they're asking you that what are the requirements. Then you will give all the clauses of prospectus. Otherwise, all these 5 documents. Yes, Pooja, written consent of expert, you can simply write down as a first line. But all these points of 389 जो मैंने अभी आपको बताए थे, वो 5 points आप इसमें लिखने जरूर. Is that clear, everyone? Okay, so the last question for today's class. Vaibhav PT Company Incorporated in Singapore having a license office in New Delhi. The office seeks your advice regarding the documents to be filed with the registrar under the Companies Act read with the rules. So now this is very, very simple. What are the documents? Can you just name the section in this one, if you remember? Okay, Manivanan says clear, ma'am. That's great. Yes, students, what happened? What is the section in this one? Simple question. Yes. Good, Manivanan. Santosh B, which section will be applicable over here? Almas. Good, Pooja. Pooja, 385. How come? Very good, Ishan. So related party transactions, repatriation of profits and transfer of funds, including dividend. Above documents have to be filed if you're a foreign company. You simply have to remember about these attaching of the following documents. So it relates to section 381, not 380. Manivanan. This is related to the accounts of the company. He's asking you what all documents are required along with the financial statements to be filed. Section 380 is about the registration. Once you have opened up the office, then what all documents are required for incorporation. 381 talks about the financial statements. Along with the financial statements, 3 important documents I just told you are repatriation of profits, transfer of profits, and related party transactions. And with this, we come to an end of our syllabus, well in time. Yes, Asta.
Ma'am, here we are only having liaison office. So will it be considered as foreign company?
So if you're having a liaison office, you have to give a description that yes, they are doing a business. So liaison office in itself is trying to tell you that it's seeking the information for filing the financial statement. So assumption of being a foreign company has been used.
ओके मैम मैम मैंने आपकी मैम मई वाली क्लासेस देखी थी फेमा वाली मैम उसमें कोई डाउट है मुझे अभी पूछ लूं
So this session was specifically for LLP and
एक्चुअली दिस इज अ लास्ट क्लास
so you can just type it in the chat box. I'll try to answer it. Okay, Asta?
ओके मैम
So yes, Manivanan.
LLP I'm asking, madam.
Yeah.
So, designated partner should one partner at least should be resident partner. Suppose he is existing from the partnership. There is no other.
Come again, come again, come again.
Madam, any LLP, one should be a designated partner, residence of India. Suppose a partnership 5%, both are eligible designated resident partner resigned or exit from the company. What time limit they have to appoint again get one more resident partner? Any time limit?
So 6 months time period has to be seen in case of the minimum number of partners fall below 1.
Yeah.
And for the partner being resident in India, it is only for one person for
Okay.
being a category of designated.
One more doubt, madam. Somebody want to incorporate in India as a foreign company. Before incorporation, if there is any issue, if they paid some money, advance, everything, if it is something happened to that person, whether they can sue as a foreign company or criminal act.
So see, criminal procedure code, it already told you notwithstanding anything for the criminal procedure code. So anyways, if you are involved in the crime, then the Indian constitution is very harsh for that. That will become applicable. But otherwise, if you are saying before incorporating, before it has become a foreign company, then we have to see whether it is a body corporate, those provisions will be applicable. Whether it is an Indian company, those provisions will be applicable. But you don't have to go into this much complications for the court.
Thank you, ma'am.
All right, thank you. Asta, for your doubts regarding the penalties, you'll have to refer to the study material, whatever it is given over there, having a limit of 2.5 per annum. Is aggregate or individually? So it is in aggregate. The limit that you're asking, it is in aggregate for all the 2.5 lakhs per annum for FEMA that you're asking. It is for aggregate. So if I've spent for foreign studies, then 1 lakh, then the limit left is 1.5. Okay, it is in aggregate has to be. All right, students, I wish you all the very best for your exams. I really wish and hope that you clear your exams with flying colors. Be very, very careful in attempting your paper and writing it down beautifully. I hope you have enjoyed the session and you are going to make us all proud of you by doing good in exams. All right, and I hope no doubts are left. Thank you, Manivanan. I'm glad that you have written that it was a good revision. And I hope all your doubts have been taken care of. So all the best, students. I will just see the chat box. I hope no doubt is left. All right. Thank you, Varsha. Thank you, Tanu. Thank you, everyone. All right. Thank you, Almaz. Yes, Asta, that will be considered for those current account transactions. And you can refer to that lecture that you were referring to, and that we have covered all these kind of points. Okay. All right. Thank you, Kirti. Thank you, students. All right. Yes, sir. We are done with the session. Revision is over. Yes, sir. Thank you so much. Thank you, sir. Good.